Okay, it is an honor to, by the way, do this with you. You should know that I am very honored. I am here majorly to talk about the court and the constitutional reforms in Uganda, what the missing link is. I am aware you're familiar with some of the questions, so I'll just start with the introduction. I'll have you introduce yourself.
I'm Peter Walubiri. Practice law in this republic.
Interesting. You are the right person.
I do politics as well.
All right. Yes, so I'll just dive right into it. What role have courts historically played in shaping the constitutional reforms in Uganda, from your perspective?
Well, the courts in this country have majorly played more of an interpretive role to interpret what the Constitution is and to guide on areas where they ought to be reformed. They have not played a central role in the reform process because that's not really their role. They try to interpret and guide what the Constitution should be, what laws are unconstitutional, which areas call for reform, and that's basically what they have done.
Okay. How has the interaction between the judiciary and the constitutional changes evolved over time?
Well, it has been a dicey and sometimes not very productive process. The courts have done a post-mortem role. Largely. The executive...
When you say post-mortem role, how do you
mean? They have come in, for example, to point out what has gone wrong, when it has already gone wrong.
Yeah, okay.
Bad legislation has been made which is unconstitutional, which fetters constitutional development, and the courts have said, no, wait, what you've done is wrong. After the Mama Mbaba's electoral petition, the Supreme Court, I think for the first time, really made some directives on areas for reform. And in that particular instance, there was very, very slow reaction from government. There was an attempt to go back to court to see whether the court can force the Attorney General to bring the necessary legislation for constitutional reform, and actually to hold the Attorney General accountable for failure. The court, on that instance, I think fell below expectation. They largely exonerated the Attorney General. He said he had tried something, but he's not alone in this. So nothing firm came out from the Supreme Court. And as we talk now, what had been recommended by the Constitution, by the Supreme Court, that Mama Mbaba's petition has never been implemented. And yet the court had made specific orders. But when the applicants went back to the court to say, you made these orders, they are not being followed, the court largely grew cold feet. So the constitutional reform process in this country will really not be moved by the courts. it will be done elsewhere.
All right. No, interesting. So we're going to look at the 1995 Constitution and the judicial oversight. Seeing you're saying it will be done elsewhere, in what ways did the 1995 Constitution empower the judiciary in Uganda? Or it did not as well?
No, the 1995 Constitution, and in particular Article 137, empowered the judiciary. In particular the Constitutional Court, by giving it jurisdiction to receive petitions from any person who alleges that a law made by Parliament or anything done by any person contravenes the Constitution. The Constitutional Court was empowered to declare laws and actions and omissions unconstitutional and to give redress. And the power is wide. Anybody can move the court. You don't have to have a personal interest. You don't have to be a citizen of Uganda. Somebody can walk from Australia and come here and he says, I was reading on the internet this law made by Parliament, I think it contravenes the Constitution. And he has locus, and the Constitutional Court has jurisdiction to interpret the Constitution, to declare laws and actions and omissions unconstitutional. It's a great opportunity, which if the Constitutional Court and the Supreme Court on Appeal had exercised well, it would have spurred respect for constitutional order. It would have ensured that there's progressive constitutional growth in this country. So the Constitution, the 95 Constitution really had that very, very progressive jurisdiction vested in the courts.
And how have the courts and the judiciary been, how effective have the courts and the judiciary been in providing oversight? In upholding the Constitution?
If you rate on a scale of 1 to 10, has been below 5, really. 1, the courts have been slow to dispose of constitutional petitions and references. And yet, the Constitution again is very clear. It says the court should set, if there is a constitutional matter, it should take precedence. But we've had cases lying in the courts for 5, 7 years, not attended to, yet these are urgent matters. 2, even where the matters have eventually been heard, the interpretation of the courts has been restrictive. There was a time in the earliest phases of the court where the court was really very, very active. It handled cases of witchcraft, cases, very many progressive cases. Over time, and I've written about this, the court became a court of technicalities. It started dismissing petitions on time bar and so on. That phase passed. The recent phase has been for the court to say there are no questions for constitutional interpretation. That if you go to the Constitutional Court, you must show that you want the Constitution interpreted. But that has never been the spirit of Article 137. Article 137 says, if you say this law contravenes the Constitution, come to court and we either declare that it contravenes or it doesn't contravene. Okay? Now they want you to first show that there is a need for interpretation, but every time I say this law contravenes the Constitution has to be interpreted. And you see, even if the Constitution has been interpreted, but if there's a repeat of the violation of the Constitution, the Constitutional Court has jurisdiction. If I'm tortured today and it contravenes the Constitution, and the court interprets the laws and says this law, this behavior contravenes the Constitution, if a week later that same sort of action is repeated, the court ought to again say, like we held last week, this set of facts contravene the Constitution. But the court is now trying to say that once a matter has been handled and interpreted, a similar matter should not be handled. It should be for enforcement. But that's not the spirit. The spirit is, every time you cry out that this action, this omission contravenes the Constitution, you should go to the Constitutional Court. The court has also been slow to grant redress, even where it has found that the Constitution has been violated.
But to the courts, what are those challenges you think they have also faced in trying to implement the constitutional norms?
Well, it is just the court's self-restraint. The courts have the power to interpret, to make declarations, to grant redress.
So they cannot in any way claim that they are facing a challenge. It's them.
No, there are no challenges.
Okay.
Of course, on backlog, the claim is that there are few justices. But I think where there is a will, there is always a way.
Yeah.
I've known civil cases that have rushed through the system very, very fast. I don't want to name names, but I've known cases where particular individuals have a case in the High Court. Within that very year, the case is heard by the Court of Appeals. The following year, it goes to the Supreme Court. But you see, it's the constitutional command that you give these cases priority. So there's no excuse. Constitutional cases should be given priority and disposed of. And the courts could adopt methods of work and procedures that would expedite. For example, to insist that there should be written submissions on these petitions.
Yeah.
You file a petition, there's an answer, you write your submissions, and the court pronounces judgment. They don't have to wait for a physical hearing. It can be done. So I think it has been self-restraint by the court.
Yeah.
There are instances where you suspect that perhaps some of the individual justices are not equal to the task. That goes to the way they get appointed and they find their way there. But the Constitution has given them the power, and they are not using the power properly. Not using the power properly.
So
look, they now have put timelines on dispose of election petitions.
Yes.
And they likely try, But electoral petitions are not more important than constitutional petitions and references. Why are they able to dispose of petitions and appeals arising from petitions in a relatively shorter time? Okay, why don't we have a similar spirit for constitutional petitions and references?
Yeah.
So the will is lacking.
So, in your opinion, also, how has the judiciary navigated issues such as underfunding, political interference, and the contradictions within the Constitution?
Well, I don't know the details of underfunding.
But so
I know that judges are some of the most highly paid public officers. Okay? By Ugandan standards, I think they earn at least 20 million a month. There are not many Ugandans, even the private sector, who consistently earn that, half of that a month. I think somebody can decently live off 20 million a month. So that can't be the problem. So once a judge has salary, I don't think they are saying they don't have paper. They have computers. So I don't know what they are, this underfunding. They are slightly few justices, but those that are there's no evidence that they are working hard enough.
Okay, maybe the political interference.
Well, judges have security of tenure. I think the political interference is more at the point of appointment, that they are appointing, in many cases, persons who are amenable to political pressure. They are rewarding.
Are you saying the appointment process is not independent as it ought to be? It is
not. You see, the Constitution makes it independent.
Yeah.
You are supposed to be having a Judicial Service Commission which recommends to the President, who appoints with approval of Parliament. So on paper, it's a very independent process. But you start by who appoints the members of the Judicial Service Commission. Who are these persons? Are they men and women of integrity, of independence? What we hear from the corridors is that the executive sends names to the Judicial Service Commission. So it's the executive advising the Judicial Service Commission to say, please, when you are advising me on who to appoint Chief Justice, I want to see the name of so and so. I don't want to see the name of so and so. Okay?
Yeah.
So, they are independent. They're supposed to be independent, but they're not exercising their independence because they think that they have been appointed these jobs as a reward. So they can't be seen to annoy a person who has rewarded them. Perhaps some of them think that they are not equal to the job. Okay? So the problem is not with the Constitution, it's with the integrity of the individuals.
So
Parliament, the vetting committee, is also just rubber stamps. Have you ever seen any judge, anybody who is not approved? Everybody who is put on the list is approved. And the approval process is really a rubber stamp. In other jurisdictions like Kenya, there's open vetting. People go and make representations to Parliament about the suitability of persons who have been nominated. Here, the nomination process is largely secretive, and the day of vetting by Parliament, they will send like 10 judges, and in 2 hours they have all been vetted. You know, nobody has
proof checked anything.
Yeah.
Yeah, I hear you. So for future reforms, for potential areas where now, from still your perspective, I would love to hear you discuss the potential areas for future constitutional reforms and the role that judiciary might have to play. The keyword here is might. What they ought to do, maybe they are not doing it in these changes.
You see, the reform will inevitably have to be much more political. You see, what we have is that public institutions in this country have been held captive by an overbearing presidency until we reduce the power of the presidency, until we reduce the power of the military. Public institutions will be held captive.
Yeah.
So we have to do a very radical restructuring of governance in this country and ensure that we overhaul the institution of the presidency.
And the security
Obviously, you
forces.
have to restore
Term limit.
term and age limits. You'll have to remove the military from parliament. You'll have to radically change how we appoint the Judicial Service Commission.
What legal considerations are at play here that can be done to really, really minimize security forces from interfering into normal running of a country?
The law per se really will not change the situation in Uganda. I think we've reached a level where until, because what we now have in this country is an army beholden on to Mr. Museveni. Many people think that we emphasize the role of the individual, Mr. Museveni. But he has held the army and the country captive. So there's no way you'll free the army from Mr. Museveni. There's no way you'll free this country from Mr. Museveni until you put in place a system for his retirement. We get fresh air and we get a commander-in-chief who does not, he holds this army from, he says, he looks at it as part of a Fronasa army. When he's talking about the history of the UPDF, and he looks at this in terms of himself Fronasa, and Fronasa and the 60s and the 70s.
And the 80s.
And the 80s. Okay? So there's no way you have a free army, freed from the presidency, with Mr. Museveni in the office. It's wishful thinking. So, in even constitutional reforms and even until you retire Mr. Museveni.
That's it.
Not.
Now the clock is ticking. As we are finalizing, we'll look at the freedom of assembly and the judiciary. So I'd love for you to explore the role of the judiciary in addressing issues related to freedom of assembly, including the repeal of the restrictive laws and transparent police procedures during the elections.
You see, like I said, the judiciary is not a free institution.
Yes.
The violations of the freedoms of assembly, of association, are so rampant that the current judiciary was never meant to handle violations on an industrial scale. You see, it's like having a domestic washing machine in your house, and now taking that small washing machine to a school or to a hospital and say this is the washing machine
To use.
The violations are monumental, they are on an industrial scale. So they can't be handled by the judiciary. I mean, if they go and shoot 51 people on the streets,
Okay.
they go and the drones take hundreds of people, and the police is not ready to assist, how can the judiciary intervene in that kind of circumstance? If every day they take political leaders and in a drone and take them to that police station on Gaza, what is it called?
That's it, not Narufenya, but
Nagalama,
yes.
How can the judiciary intervene? Do you know how many people, how many meetings are broken up every day of political parties or groups and so on? How many people are arrested beyond 48 hours? If the judiciary was to handle these things, it would not even have the manpower. The violations, like I said, are at an industrial scale, and we're trying to use a domestic appliance to handle
them. In your opinion, how can the state help handling these violations?
No, you see, the state
is the one making the violation.
Is the one in violation. You have to dismantle the current state and rebuild. But we are pretending. You see, if your shirt is torn and it is torn here and here, you can repair, you can try to sew here and patch it. But if there are holes all over,
just buy a new shirt.
You just get a new shirt. You can't patch this anymore.
Yeah, totally agree. Now, in conclusion, this has been quite interesting. You are very passionate, and almost you're saying the only solution to save us is new governance. But yes, based on past experiences, what recommendations might the judiciary have for future constitutional reforms in Uganda, in your perspective?
Well, I wish the judiciary could wake up one day and break its stronghold and assert itself and be free and sanction people in the highest offices for violations. But you see, the problem is the judiciary doesn't enforce its own orders. It can make awards for compensation, it can make orders for arrest, it can make all sorts of orders, but it doesn't have the capacity to implement them. Still the executive, without a cooperative executive to implement orders of court, the judiciary shall remain impotent. It can try and assert itself, and perhaps that will help the public to seize the opportunity and be more assertive. But there are limitations. It is working in a restrictive, limited environment. It is stunted. The soils in which the judiciary is supposed to plant the seeds of constitutionalism are very barren. They are starved of water. Okay?
Yeah.
So you can't look at the judiciary in isolation of the political and socio-economic environment. And yes, you can blame individual judges for failing to handle a case, for being timid and so on. But even if they tried to assert themselves, there's a limit.
And so much they can
to what can be done. The courts have been invaded. People have been arrested from court premises. Court orders have been abused routinely. Short of judges resigning, maybe going on strike, there's a limit to what they can do. They can do slightly better.
Yeah.
Okay, they can keep giving orders and handling these cases quickly and so on and embarrassing the state. But Mr. Museveni is beyond embarrassment. You know, if he wanted to achieve a political objective, Mr. Museveni and many of his handlers, they can even go to the city square and walk naked if it was necessary. There's no shame. How can the judiciary handle such a situation?
Now, what is your biggest hope for the country?
My biggest hope for the country is the people of this country organizing themselves to take charge of their destiny.
Thank you.